You can proceed, Counselor.
Good afternoon, Your Honors. May it please the Court. Charles Michael from Steptoe & Johnson on behalf of the respondents below, Bitfinex and Tether. This appeal concerns the jurisdictional prerequisites that must be met for a proceeding under GBL 354. Let me be clear up front as to what we are challenging on appeal and what we are not, because there is confusion on this point that pervades the trial court's opinion and the AG's position on appeal. We are challenging the particular way the AG has attempted to obtain jurisdiction in this particular GBL 354 proceeding, which is based on a particular factual predicate. In a nutshell, when the AG files a civil proceeding, it needs to follow the same rules as other litigants with regard to service and jurisdiction.
So you're talking about the method of service?
I'm talking about the method of service, but also personal jurisdiction and the statutory reach. This appeal is not about, as the AG claims, a challenge to the AG's ability writ large to investigate Bitfinex and Tether.
So it's more focused on the preliminary injunction aspect, correct?
The preliminary injunction aspect is critical because that's what
Right.
separates.
That's the focus of what you're arguing, right?
Well, we're arguing that the whole proceeding should be dismissed for lack of jurisdiction. The reason why the preliminary
Go ahead. Answer
ahead.
my colleague's question.
Sure. The reason why the preliminary injunction is so critical is it's what distinguishes this type of proceeding from just, in general, the AG investigating something.
Right.
The trial court below is exercising its coercive powers in real and meaningful ways over my clients.
Or regulatory powers,
Well,
one could also
right.
say.
I was
Sure. Right. We've been under.
I think whether you think it's coercive or not is really not germane to the issue that you're trying to raise here, which concerns jurisdiction, right? That's fair.
Right. All I
All
was.
right, so here's my question, all right?
Please.
Because to me, and I think everybody who's arguing in this, and one of the things that it seemed to me that the trial court was struggling with, and quite frankly, I'm struggling with, is that the unique nature of what a 354, you can call it a proceeding, you could call it a rose, I don't care what you call it, but it's unique. It has unique aspects to it. It's ex parte, which makes it unique. You don't have to be served before the AG gets the order requiring the turning over of documents and the preliminary injunction. So to me, so much of this procedural that's being argued by everybody is trying to fit a square peg in a round hole. Would you agree?
I would agree in part, Your Honor. It is a unique proceeding with unique features. But that said, CPLR 103B makes clear that every civil proceeding, and this is one, falls in the bucket of either a plenary action or a special proceeding.
Yeah, yes, but things are different. I mean, you made a motion to dismiss. You also made a motion to vacate. Are you entitled to any other remedy other than to just vacate the ex parte order? What's a dismissal of this proceeding look like?
Sure. The dismissal of the proceeding is dismissing it, and that's a real and separate remedy because the...
What are we dismissing? You acknowledge in your reply brief that that doesn't put an end to the investigation. They're still entitled to investigate you, correct?
Absolutely. They have a toolbox of investigatory tools.
They can serve subpoenas,
Absolutely.
and it doesn't matter, the long-arm jurisdiction that you're claiming in this particular case is not really germane to the service of subpoenas?
Well, they have tools in their toolbox, including subpoenas. We're happy to take each of those as they come. The point I was trying to make at the outset is just that the battleground for this appeal is one tool in the toolbox, this particular 354 proceeding. Now, the reason why dismissal makes sense here, and it's not just as simple as an order that's either granted or not, is there's ongoing supervision from the special master. The special master dealt with us for months. We produced 70,000 pages of documents.
What does that have to do with it? If you vacate the order, all this is they got an ex parte order. That is the proceeding. And your remedy is, and you say they didn't have a right, they didn't have jurisdiction, vacated. That's it, right? Isn't that the end of the story?
Whether you call it vacating or dismissal, I will agree that the practical effect is the same. We think we have a right to have it ended because the trial court has brought its powers upon us without jurisdiction.
But if what you're really doing is bringing this subsequent motion as another form of a motion to vacate, why should we permit you to raise jurisdiction now when you didn't raise it on the first motion to vacate? It seems to me that's a very serious problem, not that you didn't preserve the jurisdictional issue, because putting it in a footnote in your memorandum in support in your motion to vacate as opposed to in the motion itself, it seems to me does not preserve that claim, and I'm not sure that we can reach it at this time. Could you explain to me why we can?
Sure, let me address that in a few ways. The first is the practical. We were blindsided by an ex parte order.
Oh, please. You'd been negotiating with them for months.
We had no idea they were running to court, and
But the concept of jurisdiction is certainly not something that you couldn't have put in your papers without a lot of, I mean, you could have very simply put in the concept that you were not properly served. I don't think that would have taken a vast additional amount of time relative to the time you already spent in putting together your motion to vacate.
we put in a footnote that we were
I don't
challenging
think that
jurisdiction.
the practical one, for me, doesn't make it. What other arguments do
Then
you
let me
have?
get to the legal one. The interplay, there's no dispute that the interplay of CPLR 404 and 3211 is that in a special proceeding, you have a right to make a motion to dismiss and to challenge jurisdiction, including service. That's what we did. We did it less than 30 days from when this proceeding began. It would be,
But what you said in response to Justice Gish's question was really that the gravamen of your second motion was to vacate the preliminary injunction, to establish that they didn't have that there wasn't jurisdiction for that. So why wasn't the jurisdictional issue raised when you first moved to vacate?
well, with respect, that goes back to the practical issues. We got this on a Thursday night. On Tuesday morning, we're in court on order to show cause because it was so disruptive. We had the markets terribly roiled by we had been talking to them for months. That is absolutely true.
Are
But the
you
injunction
really
disrupted our
telling me that
business.
Steptoe and Johnson couldn't figure out a way to assert lack of personal jurisdiction in a motion that you were making anyway?
We needed immediate relief from the immediate effects of the PI.
Well, isn't that a business decision? So why is the court somehow restricted in what it would normally do, whereas you get one shot to raise certainly issues of service of process and give you more latitude because it was a tough job?
Well, I would note, Your Honor, the trial court agreed with us. It was right on this point. The trial court did not find we waived our service objection because we had put that footnote in the first motion. And I think the trial court has that discretion to say, I'm going to look at this afresh.
And we have the right to look at it also, so we're looking at it anew. But here's the question. I'll let you go over the time. If, in fact, we agree with you that you weren't properly served, end of story, right? We don't reach the other issues.
Absolutely. And I think it's conceded that we weren't served in the method.
And then they can bring another ex parte motion and serve you correctly.
They can use any tools in the toolbox, including this one.
And then here we are again.
All right.
It's possible.
Yeah.
We're trying to take this one step at a time.
Thank you. Counsel?
Thank you, Your Honors. May it please the Court, Philip Levitz for the Attorney General.
So where's the basis that you got Justice James to give you permission, or at least a provision in the order show cause, to serve counsel? Where, I was thumbing through it to see, because normally you would put in your papers, I can't serve them, I can't find them. So where, unless I
Right.
missed something, where is it the basis that you got them
So
to
let me,
say serve
let me
counsel?
back up and talk about the context here. So we sought this 354 order by application. In the 354 application, which, as Your Honors were suggesting, was under exigent circumstances where we had just learned about the liquidity issues that are at the center of our concerns about Bitfinex, and needed to do something to get court supervision of this process and get the preliminary injunction that Your Honors have spoken about. We went into the court, we submitted the 354 papers. Those 354 papers included, in the proposed order, language saying this is going to be served on counsel. We have been working with counsel for months before that on the investigation.
You did say that in the order, but you didn't say why in
Well,
the
so
body of the application.
So actually-
which again was a quite lengthy application. So borrowing from my colleague's question, why could you put it in there?
Right. So actually, the factual predicate is in there. So the 354 application incorporates.
see it.
Yeah. Let me point you exactly to where. So the application incorporates the affidavit of Brian Whitehurst, and if you
Right.
look at that affirmation, you'll see facts related to the impracticability of service in this case. And I can point you to the specific paragraphs that I'm talking about. Basically, the long and short of it, and let me tell you the exact paragraphs if you give me 1 second here. You can take a look, for instance, at paragraphs 7 to 14.
What paragraph?
It's on
What
pages
record?
That in the
66 to 67 of the record.
Thank you.
And what those say, essentially, is the respondent entities are a number of entities with operations all over the world, no operations in the United States, much less New York. Totally unclear who we could possibly serve on.
Sorry, 7
Where
to
is-
14 doesn't say any of that. It says that they're foreign, but it doesn't say it's impossible to serve them.
The point is, that it's the factual predicate for the impracticability. That is the basis for the impracticability here.
Isn't that
It's
the Abrams versus Luria really went the other way? They said the fact that the corporations may not be domestic corporations is not a sufficient basis for you to have an alternative service necessarily without more of a showing, right? To get under CPLR 311.
So actually, no, I don't think that's the important lesson of the Abrams versus Lurie case here. I think the important lesson of the Abrams versus Lurie case, for this case, is that the Section 355 service requirements under the general business law incorporate CPLR 311. CPLR 311 has this exception.
We
for-
understand, but you still have to make the showing for 311. I accept that
Yeah.
from that case. Let's move on from service of process, though. You go into court, you get an ex parte preliminary injunction. It's more than just a subpoena that says turn over records. What kind of jurisdiction, if any, do you need in order to subject them to that kind of court involvement?
Right, so the longstanding rule that the Court of Appeals has established here is that all that is required is that the Attorney General have a reasonable basis to believe that there could be a violation of law here. That's the LaBelle Creole case that we cite, and other cases have consistently cited the same standard over time. That is a very low
Case that
burden,
you
and
cite?
I'm sorry, that's the LaBelle Creole case. It's
Right.
10 New York 2nd, 192. That case has been repeatedly cited, and it makes good sense, because let's go back to what the context here is. The context here is that we are not talking about litigation. As Your Honors were getting at, we're talking about an investigation that the Attorney General's office has initiated based on serious concerns about misrepresentations that had been made to Bitfinex users and Tether holders. We have not initiated a lawsuit. We've initiated this investigation. We're asking for documents. And to clarify an issue that was raised in your speaking to my colleague has not challenged the preliminary injunction piece of the 354 order. So there is no basis to vacate that piece of the order at this.
He wants the whole order out. He wants
Sorry?
the whole case dismissed. Doesn't the preliminary injunction go with it? Maybe with the bathwater?
So not when any such argument has been waived, which is exactly the situation
I don't
here.
understand
Which
that.
argument has been waived?
There's no argument in the respondent's brief about the preliminary injunction, what they're
Why
challenging.
should it be?
Well, in any event,
Honestly, it goes, the ex parte order, it's all one order. If you had no jurisdiction to get it, you had no jurisdiction
Okay,
for anything. So I
so
don't know where
I
we're
still think the
going
issue has to be
with
raised, but
that.
let me focus on the actual jurisdictional issues, because
Okay.
they're completely, they do not serve the respondent's point here at all, and the reason for that is the standard that I just referred to, which is that all we need at this stage is a reasonable basis to believe that the law has been violated. We have that in spades here, and let me talk to you exactly about why. The Attorney General's investigation to date shows that respondents, at a minimum, misrepresented Bitfinex users' ability to redeem their cryptocurrency investments for cash, and secondly, misrepresented
No,
that.
there's nothing, that investigation may have gotten you all that information. My concern is you've gotten injunctive relief kind of in an easy fashion, because my understanding of when I was in the trial court is when I'm going to enjoin somebody, enjoin a defendant, that's got to be served on the defendant. What you've done here, you've got a preliminary injunction on entities through their counsel, which is an easy way of doing it. That's the problem I have here.
So
You see what I'm saying? I mean, that would mean that this case, if we were to agree with you, then going forward, all parties would have to do, all plaintiffs would have to do is they point to this case and say, I'm just going to serve the lawyer for the entity, and therefore I'm going to get you an injunction.
I don't think that's true. I think this is a very specific
A
circumstance.
very crafty lawyer will look at this and say that's the way it's going to read.
Well, we've got to, first of all, talk about the fact that this is a special feature of 354.
I understand that. I'm not disagreeing with you. I'm just saying that that's fine. The investigatory powers are separate from the injunctive relief that you got here. You're shutting down the companies. Regardless of, I mean.
So we're not shutting down the companies, and that's exactly why the respondents aren't actually challenging the preliminary injunction here. The preliminary injunction that was initially in the 354 order that was entered ex parte was in fact modified, and it was modified basically through discussion with the respondents, and the respondents agreed that the way that the preliminary injunction worked out was basically appropriate, and so.
So why are we here then?
We're here because.
Then why are we here then?
I think you should ask that question to my colleague.
I would think he begged to differ when he gets back up.
Well, I do think we should hear from him about that, but
Oh yeah,
the point
we're
is,
going to hear from him.
all this is really about, in my understanding, is for now documents. Yes, there's this preliminary injunction piece too, but it hasn't been challenged. Let me talk.
I'm going to tell you now, the way this appeal goes, if you lose it, the whole order goes out.
Well, and that
If
is
you win it,
and that is
the
exactly.
whole order stays with the preliminary injunction. Okay.
Okay,
thank
so but
you, Counselor.
can I?
Thank you.
Thank you.
Your Honor's 3 points, but go ahead, Justice.
So
Hoegner.
I was going to ask you, I got the sense that when you got up and you argued, look, investigation, the AG is entitled under 354 to investigate whatever they want. That's their authority. They can do that. Your real contention here is the injunction aspect of this, right?
In a sense, because that's based on this particular 354,
Right.
the way they've gotten
That's
this order.
That's how the vehicle they use to get the injunction.
Exactly. And let me be clear.
And by serving the attorneys instead of serving your clients.
Right. We are challenging the injunction, absolutely. If there's no jurisdiction, the whole order goes out. Let me be clear on that. Two other points, and they have all the other tools that you referred to, Justice Hoegner. Number one, we cite in our opening brief the Russell case, which holds that a trial court has discretion to reach a question of service, even if it's been waived. It would be quite unusual when the trial court reached service on its merits for this court to reverse. That would effectively have to find that the trial court abused its discretion in even reaching the question. The service question is squarely before this court because the trial court reached it, addressed it on its merits. Now, the trial court came out a different way than we would like, but I don't know if there's a case out there where an appellate court has said something that the trial court has discretion to reach is grounds for reversal for even reaching the question. You look puzzled by this, Justice Gassmer.
I was just looking at the motion to dismiss as you were answering Justice Wang's questions. And I'm just curious, your motion to dismiss, first of all, actually doesn't actually ask for dismissal, that it's also supported by an affirmation by a lawyer who doesn't seem to be admitted in New York, is he? Stuart Hoegner?
No, the reason it's an affirmation is he's physically located outside the country. It's
But
another.
is he admitted? Where is he admitted? He doesn't state where he's admitted.
I don't know
States
if
he's admitted in the United States, but doesn't state, you can't be admitted in the United States. You have to be admitted in a state. Is he admitted in a state of the United
I
States?
believe he's admitted somewhere in these United States. I can't tell you the state, but the opening paragraph.
If that had been submitted to me in the trial court, I would have raised a question about it. I'm just curious if that was ever raised.
That was not raised. If I may just address that question, there is a newish provision of the CPLR. I can't tell you the year that says when people are physically
I
outside.
understand about the affirmation. I'm curious about where he's admitted. It doesn't say.
It doesn't say, but I don't know why his admission is relevant to anything. He's a fact. He's a fact witness.
Fine, I'm curious.
So he's just presenting the testimony about how tethers work and some of the things about the
It
business.
should have been an affidavit.
Well, he was physically in Canada when he executed.
So he can sign it, and we get plenty of affidavits from Canada, and they're consularized, and they come, and they're otherwise authenticated, but that's a different issue.
was
for a
just
different
curious.
day.
Right, that's not an issue that's been raised.
No, I
I'm gonna ask
understand it
you
has
to-
been raised.
I'm
I was
gonna,
just-
right, I'm going to ask you to wrap up. Thank
Thank you, Your Honors.
That's a good wrap-up. Thank you. It's interesting.
Notice it was,
I didn't see it either.
no, I just went to look at the motion because it didn't make sense to me.